Yes, good afternoon, Your Honor. This is Zheng Liu on behalf of the Appellate. Your Honor, are we waiting for the opposing counsel to state his appearance, or should I start? Okay, thank you, Your Honor.
Could you speak up? I'm having a hard time hearing today. Thank you.
Yes, thank you, Your Honor. Your Honor, this case is appeal from a trial court's denial of an anti-SLAPP motion. The gist of the appeal is, can you counter-sue people in the same lawsuit because they sued you in the first place? You can't. At least not before the first lawsuit has been terminated in your favor. For example, by way of a malicious prosecution case, right? This is not that, because the first lawsuit is still pending. So you cannot assert a counterclaim for people suing you in the first place, because people suing you is a protected activity under the anti-SLAPP statute. And then that's precisely what happened here. The facts are simple in this case. Wu, she's a landlord in San Francisco. She rents out one of her rooms in her house to a third party. And then Zheng was a family friend of Wu's mom. Zheng was charged with collecting rent from the third party. And then for a while, Zheng collected rent, but never gave the rent back to Wu, who has been a landlord for this entire time. And then after several attempts, and after a demand letter, finally Wu sued Zheng for essentially conversion because Zheng kept Wu's money, and sued Zheng for breach of fiduciary duty because Zheng was acting as an agent of Wu when he collected rent from the third party. And then after that, Zheng countersued Wu for a lot of things, essentially asserting 5 different cause of actions. The cause of actions issue on this appeal is the fraud, 2 counts of fraud, one kind of fraud against Wu, actually. The other kind of fraud is against Wu's mom. Essentially, the issue on appeal here is a fraud action Zheng brought as a counterclaim against Wu, and a conspiracy claim Zheng brought against Wu. The gist of these 2 claims are essentially, Zheng says Wu's lawsuit against him is itself a fraud. Wu's theory is, Zheng's theory is Wu conspired with her mom to essentially come up with this huge conspiracy, which was Wu's mom would agree that Zheng would somehow collect the rent on her mom's behalf. And then all this was never communicated to Wu at all. And then, so that Zheng was collecting rent on behalf of Wu's mom. And then Zheng was capturing the rent on behalf of Wu's mom. Again, none of this was ever communicated to Wu herself. Therefore, Zheng says in his counterclaims, Wu's suing him in the first place is itself a fraud and is itself a civil conspiracy.
No, but he's not saying it's itself a fraud. I mean, you have to, I think, as I understand it, this is an anti-SLAPP, and you have to get past the first prong, which is whether there's protected activity.
That's right.
And this is not saying, as I understand it, that the demand letter itself is the basis of the lawsuit, or that the basis of the cross complaint. It's evidence of the fraud. It's not itself being sued on as the protected activity. It's evidence of the conspiracy and fraud that Mr. Zheng claims was perpetrated on him by Wu.
Yes, Your Honor. I think Zheng is saying that the fraud includes both the demand letter as well and the lawsuits, because Wu's lawsuit specifically included a conversion cause of action, right? Zheng refers to basically Wu was falsely accusing him of converting the rent. That quote-unquote converting, that can refer to nothing but the conversion cause of action Wu asserted against him in her original claim. Right? There's nothing else. The word converting unequivocally refers to Wu's conversion cause of action. Right? There's nothing else.
But the causes of action that are asserted, that are at issue here, as I understand it, are the causes of action that are not against the mother, but solely against Wu. Is that correct?
That's right.
And as I understand it, those causes of action are common count, fraudulent deceit, and conspiracy.
That's right. We're not appealing the common count action in this appeal.
Okay. Well, fraudulent deceit and conspiracy, those are the two?
That's right.
Okay. Well, fraudulent deceit is not conversion. It's fraud.
Yes, Your Honor. The fraud cause of action, the underlying facts Zheng asserts to support his fraud cause of action is Zheng Wu, in her original claim, falsely accused him of conversion. That's the key here, Your Honor.
Well, no, it's more than that. It's that the mother initiated a scheme in asking Zheng to rent out the apartment, collect the rents, transfer the checks in cash, transfer the money in cash so there wouldn't be checks, there wouldn't be evidence, and that Wu was aware of the scheme, and she agreed that she'd avoid paying back the money. She agreed with her mother that she'd avoid paying back the money that Zheng had loaned to the family, and that Wu helped Zheng carry out the scheme. This is all a scheme, alleged scheme, by falsely accusing Zheng of converting the rents in an amount that would cancel out the debt. And so the demand letter is evidence, Mr. Zheng says, of the fraud.
That's right, Your Honor. So I appreciate the court's pointing out that aspect. So yes, the court is correct in noting that Zheng's fraud claim covers both protected conduct and unprotected conduct.
Yeah, I don't see that.
Right? So also, again, just sending the other party a demand letter itself is a protected activity, right?
I can't hear you, I'm sorry.
The demand letter itself is a protected activity.
Demand letter?
Yeah, because that's pre-litigation demand letter. That's protect itself, especially in view of the fact that a lawsuit was actually filed immediately thereafter, within a week. Right? You cannot say the demand letter is not protected in view of the fact that a lawsuit was actually filed, because the demand letter is protected because it was contemplated in a serious litigation that actually took place a week ago. So sending somebody a demand letter is also protected under the anti-SLAPP statute. Right? So again, I think the Supreme Court has held in the Burrell case, I think Burrell case is controlling that if a cause of action includes both protected activity and unprotected activity, the analysis for a anti-SLAPP motion is we disregard the unprotected activity.
I understand what Burrell says, but you still have to convince me, or us, I mean just me,
yeah, right.
All of us obviously, but you have not convinced me that the cross-complaint is protected, that the demand letter is protected activity, because the way I understand it, the cross-complaint refers to the demand letter, and it refers to Wu's claim that Zheng converted the rental records. But Zheng is not alleging that the demand letter itself or the complaint itself gave rise to his cause of action for fraudulent deceit. He's saying that this is evidence that supports his claim that Wu, who's the nominal owner of the property, was aware of the arrangement requiring him to collect the rent and transfer it to Wang, and that Wu and Wang intended to avoid paying him back any of the money he'd loaned to them. And if that's the case, then you don't get to Burrell because it's not protected activity. So how can you respond to that, the differentiation between alleging that the demand letter gives rise to the cause of action, which makes it protected, versus it simply being evidence of this unlawful scheme that is itself the cause of action? Yes,
Your Honor. I think the test for whether something is protected activity or not is the arise from test, right? The arise from test says whether a cause of action implicates protected activity or not. We look at the underlying facts, and then we determine whether the facts describe protected activity under this anti-SLAPP statute or not. And I think the broader description here is Zheng says the whole thing is a fraud. The whole thing includes, as you already just described, some checks, and there was asking Zheng to collect the rent, but without telling Wu, or was trying to insulate Wu from this, and then later ask Wu to file a lawsuit against Zheng, right? Zheng said the entire thing itself is a fraud. So the fraud, he says, includes several parts. First of all, doing all these checks and asking Zheng to basically setting up Wu as a nominal owner. Second of all, asking Zheng to collect rent on Huang's behalf, right, without telling Wu himself. And then the third was essentially now Huang would say something else to make sure that Zheng keeps doing his work. And then the fourth would be eventually ask her daughter Wu to send a demand letter. And then finally, Huang would ask her daughter to essentially sue Zheng. And then that's what Zheng says is this grand fraud, right? That's what he's saying. So therefore, based on Zheng's own arguments, the fraud includes all these different parts. Collecting rent, not essentially appointing a nominal owner, and then collecting rent, and then basically holding the rent for Huang, but not for Wu, and then ask Wu to basically not being part of this. And then again, the focus here is the fourth and fifth part, which is, again, then eventually ask Wu to send Zheng a demand letter, and then finally ask Wu to sue Zheng, right? That's the grand fraud Zheng is alleging in his counterclaim. But again, clearly the fourth and the fifth part, they're protect activity, because the case law is clear. A pre-litigation demand letter is undoubtedly a protect activity, especially when it was done in contemplation of serious litigation, which happened in this case. It was not a just superficial discussion, oh, I may or may not sue you, a bunch of fluffy words. It's not that. It was, demand letter was sent out roughly a week before the litigation was filed. And then litigation actually was initiated. So Zheng says, okay, the whole thing was a fraud, and the fraud includes you sending me a serious demand letter, and then the fraud includes you suing me for fraud, right? So therefore, based on Zheng's own allegations, the fraud is this big fraud. But again, I would ask Your Honor to look at the description here is because this alleged big fraud includes protect activity. First of all, the first protect activity is sending a pre-litigation demand letter. And then the second protect activity is actually suing people, right? Bringing a lawsuit itself is undoubtedly protected activity under the anti-SLAPP statute. There's no way around it. Maybe you can sue people for malicious prosecution, but only after the first lawsuit ends in your favor, not in the middle of it. Otherwise, everybody have a counterclaim. You sue me for whatever, I'll counter-sue you for malicious prosecution in the middle of the same lawsuit. We don't allow that, right? So that's what we believe are the two kinds of protected activities in this case. And again, under Burrell, I would say, Your Honor, your analysis might be conflicting with my understanding of the Burrell, because Burrell says we look at what, again, during the first step analysis, okay? So we disregard all the unprotected activity. We look at the protected activity itself, okay? Because we don't consider, because, our for pleading, everybody can include some unprotected activity. In that case, then the anti-SLAPP statute would never work, okay? Because any smart lawyer would just add something that's not protected, the whole thing goes to trial. That defeats the entire purpose of the anti-SLAPP statute, which is basically, just terminate meritless lawsuits or meritless claims at an early stage, okay? So therefore, Burrell says when at the first step of analysis, we look at the protected activity itself, and then we do not look at the unprotected activity. So in this case, yes, Your Honor. You have a question?
No, I'm just listening.
Yeah, so under Burrell, we only look at the two things here, which is Wu sending Zheng a demand letter in serious compilation.
I must say, I'm just listening. I understand that the first and fundamental question on prong one is what is the gravamen of the cause of action? Do you agree with that?
Actually, I do not agree with that, Your Honor. So,
Don't agree with that.
yes, Your Honor. In some court of appeal cases, the gravamen test has been abolished.
Abolished?
Yes.
What case says that?
I don't have it in top of my head, but it's actually in my opening briefs. So some court of appeal has indicated after Burrell that the gravamen test has been abolished. Or the primary thrust test, or primary claim test, whatever you call it. But there's a case, a bunch of cases actually we cited in our opening brief. So we don't look at the gravamen test anymore after Burrell. Because again, right, the problem under the gravamen test is any lawyer can add bunch of unprotected activity allegation into their claim. Therefore, if you look at under the gravamen test, it kind of defeats the purpose of the anti-SLAPP statute, which is terminating meritless claims at an early stage, right?
Let me just say, you keep saying the same thing. That doesn't speak very highly of your profession to say that a lawyer can do this. Yes, a lawyer can do this. But a lawyer who's doing that does it with some peril, because if it turns out that the cross-complaint is frivolous or without any basis whatsoever, you will have a remedy at the end when you win the cross-complaint, right?
Yes.
That's a remedy for malicious prosecution. But let me just say to you, this is not our first SLAPP case that we've had in front of us. It's probably our 50th. I mean, I don't know. But we're fairly conversant with what the law is. And I guess in listening to you, you keep wanting to go back to the demand letter. I don't understand that the demand letter is the basis or the thrust, to use your words, or the gravamen, to use my words, of the cause of action. It's evidence, as Justice Miller points out, apparently that they're going to use. But you keep talking like the people can do this and do that and do this. We know about SLAPP. We know Burrell. We know, I guess it's fair to say, we're fairly conversant with what the law is.
Yes, Your Honor, I agree. If we look at the pre-litigation demand letter by itself, I understand that somehow could be evidence of this fraud. Right? I agree with that. But again, I would have to go back to the opening brief to find the citation for the court. But my belief is, because I've done a few anti-SLAPP motions myself, I believe after Burrell, at least some court of appeals, at least there is a split of authority with respect to the gravamen test after Burrell. Because some court of appeal has specifically stated that after Burrell, they have abolished the gravamen test.
Okay, but counsel, here's the thing. I think you still have to have, whether you say it's been abolished or not, because I understand Burrell will allow, in certain circumstances, the striking of certain language from a cause of action, even though the cause of action stays in the complaint. But you still have to analyze with anti-SLAPP what's really going on. And is this really a lawsuit or a cause of action that's brought to affect somebody, to sue somebody based on a meritless claim based on a public activity, anti-SLAPP. And to me, when I read this complaint, the actions that gave rise to this cross-complaint for fraudulent deceit, they arose way before this demand letter was written. This scheme that's alleged to repay Mr. Zheng is described, and it all is taking place way before the demand letter occurs. And so and in addition, Mr. Zheng is not seeking damages like defamation or emotional distress as a result of the demand letter. The demand letter is just one piece of what he alleges is a fraudulent scheme that started some time ago and took various different forms to defraud him. And when you look at it in that way, I don't know whether you call it gravamen or whatever, I don't see where there's protected activity here. That's just my view. I just don't see it for either cause of action.
Sure, Your Honor. I mean, I think, Your Honor, I agree with you that a lot of Jones' allegations were about things that occurred about a decade ago almost, right? But I think what's kind of missing from the appeal is after Zheng countersued, he sued both Wu and Wu's mom. But then he ran into this great difficulty serving essentially Wu's mom, who is a Chinese resident and Chinese citizen. So that part of the cross-complaint could never progress. In fact, Zheng tried to serve.
How is that relevant to the anti-suit?
The relevant is, again, that I think to us is evidence that basically Zheng is trying to use the Wu's lawsuit itself to somehow assert liability against Wu, because he knows that all his claim was with respect to Wu's mom, but he could never serve.
Maybe that's prong 2 or some other issue, but that's certainly not prong 1. We're still at prong 1. And I wanted to ask you, yeah, okay, go ahead. I wanted to ask you another question, which is, how do you deal with the fact of compulsory cross-complaints? I mean, he's been sued for owing this money.
Yeah.
And he says, wait, I don't owe you money. You've taken money from me. I mean, that to me is another, you've fraudulently deceived me. To me, that's another reason why.
Yeah, I agree with you, Your Honor.
I don't see this as some, per se, public protected activity.
I agree with you, Your Honor. I mean, people are entitled to assert counterclaims, especially those that are compulsory. I agree with you, Your Honor, on that 100%. But I think the problem here is you cannot assert allegations about the person suing you and then use that as part of the fraud. That's my argument, Your Honor.
Okay.
Let me ask you a hypothetical.
Sure.
Suppose that instead of suing Zheng, your client wrote her letters or took the position, look, you owe us all this money. I don't know what we're going to do about it, but you owe us a bunch of money. You're this, you're a cheat, you owe us a bunch of money. You owe us a bunch of money. And Zheng, against that background, says, whoa, this is causing me tremendous distress, and Zheng sues for fraud. That's the first case out of the box. Can you slap that case?
If after Wu first...
No suit by Wu.
Okay.
Wu's just giving Zheng a hard time. And finally Zheng says, I've had enough.
Okay.
And sues for fraud, the very claim that she's making here. You've described it yourself as it's everything. That's what you said. That's everything.
Yes.
That's part of the fraud case. So there's no suit by your client. It's not a counterclaim. It's an independent claim for fraud. Is it a slap?
I don't think so, Your Honor.
No.
Yeah.
So that's, in other words, your entire position is, I guess, based on the fact that it's a counterclaim.
And I think my position is one step nearer, actually, because it's a counterclaim, but the underlying supporting allegation is Wu sued Zheng in the first place. That's my point.
So you're saying that the first person who rushes to the courthouse gets to avoid a compulsory counterclaim filed against them?
Not necessarily, but you cannot at least not sue that person for suing you in the first place, and not until you have a result that's the first lawsuit has terminated in your favor.
I don't know. I mean, if you didn't sue and you didn't raise the issue, might you get thrown out of court if you didn't bring a compulsory counterclaim?
No, my issue is not with the compulsory counterclaim. It's fair to do that. I take issue with the fact that Zheng thinks that, or alleges that the first lawsuit itself is fraudulent. You cannot do that within the first lawsuit,
okay,
right? So that's my point.
Okay.
Yeah,
I understand.
because the first lawsuit is still ongoing, therefore it's protected activity. If you're just saying bad things, it's fair for people to sue, and it's fair for people to bring counterclaims. That's my point. But the fact that people have sued you, and then the first lawsuit is ongoing, you cannot countersue them for suing you in that very lawsuit. That's, I think, the protected activity. We're doing some very focused motion here. We're not saying that the entire thing you cannot sue. No, that's not what we're saying. We're focusing on first of all, the pre-litigation demand letter and the fact that you were countersuing the person about suing you in the first lawsuit. It's a very narrow and targeted point. We're not suing people because they sued us, or we're not saying you cannot bring counterclaims. Yes, you can. Of course you can.
Where in the cross-claim does Zheng allege that the first lawsuit was fraudulent?
He didn't say that exactly, but very close. He said...
What did he allege?
He alleged that essentially Wu came up with this conspiracy with her mom, Huang, and then part of this conspiracy is falsely, quote-unquote, falsely accusing Zhong of converting the 88,000. Right? The phrase, quote-unquote, converting refers to nothing but Wu's conversion cause of action. There can be nothing else about that. Right? It's very clear. Right? Zhong himself said multiple times in each of the allegations supporting each of the cause of action he has, he says he takes issue with the fact that Wu has dared to sue him for conversion. Right? He's saying that the fact that you sue me for conversion, that's part of your fraud. That's why we take issue with that. We don't have issue with people asserting counterclaims because it's a fair game. When everybody's in court, they're afraid to assert claims, and then we just resolve them all together. We're fine with that. But again, you cannot sue people, counter-sue people because they sued you, and then you cannot do that in the very first lawsuit that sued you. That's my point.
Hello?
Good afternoon, Your Honor. May I please call?
Sir, could you
You're
speak
going to have
up,
to get
please?
nearer the
We
mic or
can't hear you.
something.
Oh, can you hear me?
Hardly.
Oh. How about I get closer?
Can you hear?
Is that,
I can't hear.
Is that better?
No.
Let me shout a little. Is that better?
Yes.
Okay. This is Zheng Liu for the respondent and cross-complainant Zhang. I believe this case, the first thing I want to say is this case is about the cross-complainant's case is about he trying to recover the more than $87,000 he loaned appellant and cross-defendant Wu and her mother, co-defendant Huang, and it's not.
Counsel, I think that
Yeah.
your papers are on top of your microphone, so we're hearing a lot of scratching of your papers, but we're not hearing your voice.
Oh, I'm sorry. Is this better?
Yes.
Oh, okay. Good. Sorry about that. So basically, this case is not about. The cross-complaining is not about the lawsuit or the demand letter, and we have never in any place alleged that the sending of the demand letter or filing of the suit is fraud. In contrast to what appellant is saying, this suit is really about the scheme that her mother and Wu's mother Huang and Wu came up with to basically not repay the loan that Huang has borrowed from my client Zhang. And Zhang, at most, the Zhang is really when he received the letter and later the demand, it might have triggered the cross complaint, but the cross complaint is definitely not based on the fact that Zhang, the fact that Wu sent the demand letter and filed the suit, or even that Wu is not recognizing the rent proceed that Zhang gave her mother's Wu is just a matter of the calculating of the damage, and they are trying to. In fact, it's funny that Zhang has collect rent for that apartment and sent it to her mother Guang for almost since 2015, and suddenly Wu was saying that he hasn't gave the money to her mother only since November 18th, which somehow come down to the amount that they're asking for repay from Zhang is exactly about the amount that they actually owe Zhang for doing all the remodeling, even paying for evictions and everything. So the letter is the letter and the suit are just evidences, and they also kind of demonstrate to Zhang that they are not recognizing the rent proceed that Zhang had tendered Guang. Also, it's additionally they are repeatedly referring to some sentences in the cross complaint under the cause of action. Basically, two sentences. One say that Wu fraudulently accused Zhang of converting and rental proceeds totaling $88,000, and the other say that Zhang was harmed due to the accusation. Interestingly, neither of those sentences actually talk about the demand letter or the suit. It's really the underlying fact of the letter and the suit are the fraudulent conduct, not the suit itself or the demand letter itself. So I think additionally, the appellant talk about cross complaint. In fact, cross complaints almost always involve the same underlying dispute alleged in the initial complaint. However, it usually did not arise from the filing of the complaint and should not trigger anti-SLAPP statute. This is noted in, for example, Kajima Engineering and Construction and Learning Data Corp, the two cases. And then in this case, is this good example. We are not asking for them to stop the lawsuit or even suing them for defamation. So this has nothing to do with the act of the lawsuit itself. With that, we believe that the trial court actually is correct in ruling that appellant didn't pass the first prong test to shift the burden. However, we think the trial court actually erred in not denying the motion in the first place for late filing, because the motion was filed a total of 3 months after the cross complaint was served, and this is against a 60-day limit set in the CCP 425.16f. And the appellant has offered no evidence whatsoever to justify the late filing to the trial court either. So we actually, request that the court either affirm the trial court's decision or have the trial court amend its decision to actually deny Wu's motion based on late filing.
Okay, Mr. Lowe, thank you. Mr. Liu?
Yes, Your Honor. Briefly, Your Honor, I appreciate the court bringing, into the argument that, there are actually other.
Microphone.
Yeah, sorry. I appreciate the court bringing forth their point that there are actually other remedies to deal with the fact people essentially make false allegations, right? So I appreciate that. But the problem with that is, yes, you have to win the first lawsuit. You have to go through a bunch of discoveries, right? And then eventually go through a summary judgment motion, finally win the lawsuit, and then bring a malicious prosecution claim because of the false allegation. But then that's one way to get there. But anti-SLAPP statute provides a speedier and cheaper way to do that, right? So we're entitled to avail ourselves to the benefit of the anti-SLAPP statute. That's that. So the fact that there might be some other remedy provided by statute or by way of a malicious prosecution lawsuit, that's that. But again, where the anti-SLAPP statute provides a cheaper and speedier resolution. That's one point. The other point we're trying to make is...
But having said that, one of the things that we haven't touched on here, because it's perhaps not relevant, is we haven't even reached prong 2 yet. It's not like because if you were to win prong 1 that you're going to win the SLAPP, right?
Yeah.
So it's not very hard to win in prong 2 unless there's total privilege, and I don't understand that would be any. I don't want to get into prong 2, but you're just kind of assuming that if it's a protected activity, that's the end of it. That's not the end of it.
No, not at all.
Yeah,
Your Honor,
I'll say.
Yeah, Your Honor, briefly for prong 2 here, again, the law is clear. There's no conspiracy cause of action. It's a theory of liability, so you cannot assert a conspiracy cause of action, right? So that's that. We win, hands down. There's no dispute about that. And then the fraud, again, I think our position is...
I don't want to hear about prong 2. It's been briefed below, right?
Yes, what?
Right, and we can get there if we go your way on prong 1. But we've gone a long time, and nobody's mentioned prong 2 but me.
Right.
You just seem to think that a SLAPP is just hunky-dory, and if you got a SLAPP case, you win and everybody goes home. And as I say, we're fairly conversant with what happens.
Right, okay, thank you, Arthur. I think the second point I want to mention is it's important that, we prohibit a counterclaim based on the fact that people have sued you in the first place. The reason why is clear, because at least there's reason behind it, because here, the cross-complaining, right, the defendant / cross-complaining is asking for punitive damages against our client for basically bring this supposedly, quote, fake lawsuit, a fraudulent lawsuit in the first place. So when it gets to trial, they got to tell the jury, hey, the lawsuit right now itself is...
Mr. Liu, it's not like you're talking to a bunch of numbskulls up here. There's all sorts of remedies if you don't have a punitive damage claim against you that's valid. So the idea that all these parade of horribles is going to happen, at least it's not resonating with me. I can't speak for my colleagues. But if there's no punitive damages here, you'll get rid of it in no time flat, right?
Yeah, that's right.
Okay, well, let's just deal with reality.
Sure, yes, Your Honor. I would say, again, our anti-SLAPP motion is a very narrowly focused motion. Again, we talk about two things that are subject to our motion. We ask the trial court to strike first allegations about the pre-litigation demand.
This is rebuttal to what he said. We're not going to hear You spent a long time, we gave you a long time, you know what you're talking about, so let's just rebut, and then we'll call it a day.
Sure, Your Honor. Then I have nothing further, Your Honor.
Pardon?
I have nothing further. Thank you.
Okay, thank you. Then the case will be submitted and we'll be in recess.